All right, everybody, welcome to the Creative Finance Collective. We're here to talk about all things related to creative finance. If you have any questions, make sure to post them in the chat. We're here, and we're taking any questions that you, the audience, may have pertaining to creative finance. So if you got them out there, now's the time to post them. We'll be checking the chat periodically throughout the hour. We have so for attorneys that we have here today, myself, Andy Fowler, Drew Jenkins out of Georgia, and Alabama is here, Sean St. Clair, and Scott Horne, I see, is on. Scott, can you hear us?
I can hear you. Can you believe that?
No,
I am getting more technologically savvy.
yeah, I,
I'm just driving, unfortunately, wise I'm on the speaker only right now.
yeah, no, we understand that. We want you, we know how dangerous those roads in Texas can be. We want your eyes on the road. So we'll
Oh,
take your
come on,
audio.
Andy. You need to come to Dallas and drive with me.
They don't even have a speed limit down there, do they? I always hear that
That
their
better?
highways are. Is it all open to interpretation, the speed limit there?
Well, the way I drive it usually is. You know,
No.
when you
All right,
see
good.
Scott Horn coming, because I'm usually talking on the phone, driving, drinking coffee, and trying to nibble on something, you want to get the heck out of the way.
Yeah. Um, Drew, how things in Georgia been treating you?
Things aren't slowing down, that's for sure. I would have anticipated that coming up on the holidays, normally we start to, trend downwards and stay, pretty soft until March. But in this case, that doesn't seem to be happening this year. So I'm quite pleased with it. We got all those snowbirds still moving south. So that's been helping us quite a bit.
Scott, how things still staying busy in Texas? Can you hear us, Scott?
I can. I don't know why I've got a bad connection, but I appear
Oh,
to.
no, you sound good coming through here. I just
You guys hear me okay
Yeah,
or not?
you're coming through fine. I had just asked if how things in terms of your office and creative finance, you still staying busy on in Texas?
Andy, nod if.
I can hear you, Scott. It just looks like maybe you're having trouble hearing me.
Yeah. I tell you what, I'm going to try to hang up and see if I can't
Yeah, go for it, Scott. So
Well, so I
go
was
for
going to
it,
say,
Drew.
one thing I'm seeing is I'm starting to see more novations out here. I know that that's more in the realm of y'all out west, but I'm beginning to see more and more of those come this way. And there's still a lot of confusion on how they should be set up correctly. And I have one right now where the buyer's agent um, is really confused because they're like, well, how do I get paid? Right? Because obviously he has a 2.5% commission. And he called me, it's like, how do I make sure I get paid? Because the seller's broker says that the seller is a customer and he's not willing to sign. We have everything is done by forms, right? We have very standardized forms. And the seller's broker is not willing to sign an F255, which is what we call our commission agreement or commission split agreement, right? And it's like, well, that's because your seller's agent is not actually the seller's agent, right? Like he doesn't quite grasp how this thing is supposed to work. He just wants to make sure he gets paid. And he's totally at a loss to how he's supposed to get paid, and he doesn't understand it. And I think a lot of the guys that operate with novations here, they don't understand how they're supposed to work either. And so I think if we could talk about novations, I think that would be really helpful.
Yeah, so let me jump in and talk about that. So, the way you get paid on a novation, and a lot of people misunderstand this concept, is you, so you get paid on a novation because you have an existing contract and you have the right to purchase the property under the existing contract that you will then surrender or cancel as a result of the new contract. And you'll release your memorandum as a result of the new contract. And so you're entitled to either a release fee or a cancellation fee as part of that. And so generally what you do is you define what that is in like an innovation addendum to the purchase contract that basically says, hey, look, to the extent that a third party buyer becomes part of this and you enter into a contract directly with that third party buyer, I will novate or agree to cancel my contract and release my memorandum upon payment of, and then you have some definition, 80% of the difference between my purchase price and the third party's purchase price, or 100% or 50% or whatever number it is. And that's generally how you get paid in a novation scenario.
Right. And in this case, we have a buyer's agent, right? The end buyer's agent wants to make sure he gets his 2.5%. And so the question is, who should his contract be with? In my mind, it's, generally when we have assignments, right? The buyer's agent gets paid out of the assignor's assignment fee, right? That's normally how we structure those. But in this case, with the novation, there's not really an assignment fee. You said it's a release fee.
Okay, so yes, that's a great question. So in that case, and normally the novation addendum will say that you get paid, say 100% or 50% or 80% or some percentage of the difference between the two contracts, minus any amounts paid, for commissions, additional seller concessions, additional seller closing costs. So if the end buyer and this, if the original contract says that the buyer was going to pay all the closing costs, and then the end buyer is going to, says, well, I want to do 50-50, then that amount comes out of the cancellation fee. And so normally that's what the novation addendum provides. And so the party generally responsible for paying the commissions would be the original buyer who is receiving the cancellation fee. However, if you're an agent, you need to kind of figure that out and have a contract in place with that, original buyer that basically says, yeah, you're going to be responsible for paying my fee out of your cancellation fee, or my commission out of the cancellation fee.
And that's what I was trying to explain to him, but he had never seen a novation. He was just totally confused about the structure because again, novations are not common out here yet. And so and again, I know you and I have discussed this briefly before. We're seeing all kinds of weird things. It has nothing to do. They don't file notices of record. Like they have contracts that literally say, when I find a replacement buyer, we're going to cancel this one and you're going to enter into that one. And it's like, that's looking really close to a commission, right? So I don't touch those with a 10-foot pole. A lot of people here, and there's lawyers that deal in this, but they don't seem to have the approach that you have. They just treat it kind of like a weird assignment, but instead of just assigning the existing contract, we're going to terminate once I find you a replacement buyer, which again, to me, that starts to look an awful lot like a commission. And, if you're a licensed realtor, sure. But if you're not, that's a little too close.
Well, it is.
Flying to the sun, I think.
If you're receiving a payment, not a payment, if it's structured in such a way that the seller's paying you a set amount to find a replacement buyer, that's why you have to call it that's why it has to be a cancellation fee. I mean, look, Drew, no different than an assignment. It's the same concept, which is you go and you find a replacement buyer for you, but you're assigning the contract. And the reason why, at least here in Arizona, that doesn't violate our licensing statutes when you get paid a fee to assign your contract is because you've taken an actual interest in the property. And so someone with an interest in the property can buy and sell their own paper or their own real estate without having to have a license. And it's the same concept with in a novation, which is I have a valid contract that I could enforce tomorrow, but I'm choosing not to. And in order for me to give up that right, I'm going to take a fee. I'm going to take a cancellation fee for that.
Yeah, I wish ours were structured more like that, so it was a bit more straightforward rather than, hey, when I find a replacement buyer, we agree that we're going to cancel this one and move to the new guy. And obviously, as
Well,
lawyers,
that's
wordsmithing is
what the
everything.
novation addendum says, but not in
Yeah,
such plain language. It
right.
basically
And
says,
those are
hey,
the
look,
ones that I've generally seen.
right.
Yeah,
Hey, look, if a third party buyer is identified, and it doesn't say who's identifying them, if a third party buyer
right.
is identified and the seller, the seller will cooperate, or the seller enters into contract with that third party buyer and they close on it, then our contract will be deemed canceled effective as of the closing date, and then as payment to us for giving up our rights under the contract, this is what we get.
And I see we actually have a question, it looks like,
Yeah,
in the chat.
we do have a question. And by the way, if you're just now joining us, it's a Creative Finance Collective. We're talking about real estate and creative finance and wholesaling. So if you have a question, make sure to put it in the chat. We'll be taking questions throughout the hour. The question here is, in case of a B to C novation contract canceling with forfeited earnest money deposit, who would be entitled to the EMD, the earnest money deposit? We've seen that EMD is sent to the actual seller, but how can we set it up so the earnest money deposit comes to us?
I mean, is it a BC or is it a novation, right? I mean, if you're doing a double close, it should go to you, but if it's actually a novation, then, the assignor or the wholesaler or whatever you want to call it, the original buyer is no longer a party to the contract. The contract's between, the real seller and the real buyer, and there's a cancellation fee. So, I mean, you'd have to redo your paperwork, right, somehow. But I mean, if the contract says the seller gets the earnest money, the seller gets the earnest money. If the seller's your original seller, it's your seller, right?
So yeah, in a novation scenario, the original buyer should never get the replacement buyer's EMD. That should always go to the seller. But if your novation addendum is set up right, it'll provide that the seller releases that if they receive an EMD from the end buyer that is equal to or greater than, or the replacement buyer that's equal to or greater than your EMD, then your EMD is released back to you in the event that it cancels and everybody is canceled and the transaction doesn't close. The problem is you don't want your EMD released if you think that, let's say the replacement buyer fails to perform, but you still have time to either perform under your contract, or you have, like, say, a 10-day cure notice and you think, well, I might be able to assign or whatever. You don't want to get your EMD back because that means your contract's canceled as well. Bottom line is, if it's a novation, the original buyer should not ever receive a forfeited earnest money deposit from the replacement buyer, because the original buyer is not a party and should never be a party to that contract. That's not the way a novation works.
It seems to me, Sean, you might remember this, but there was a period of time where the influencers got a hold of the term novation, and it sounded like this cool new sexy strategy with a fancy name, so it was being promoted heavily, and maybe that's why it's just showing up in Georgia all of a sudden. It's just moved east and ended up there, but seems like a few months ago, maybe in the last year, that was kind of a trend, and I don't know if you're seeing that as much. I haven't heard as much about it. Seems like some of the popularity of that's died out. It's not really the preferred way to set it up, is it?
Yeah, I mean, there's a lot of liability risk involved in novations, and you really have to have a good relationship with the seller and know what you're doing to really protect yourself in the transaction. But I think to your point, Andy, I don't think that that's even popular anymore much because of the fact that, you know, a novation generally contemplates that the replacement buyer is getting traditional financing, and nobody's wanting to buy with traditional financing anymore. You know, they all want subject to and, you know, assumptions and that type of thing.
So the individual who asked the question made a follow-up and stating it's not our EMD, it would be the replacement buyer's earnest money deposit. Does that change the
Correct.
scenario?
No, that you as the original buyer should never get the replacement buyer's earnest money deposit because you're not a party to that contract. And that's what a novation is. You aren't a party to the contract. The contract that closes escrow is directly from the seller to the replacement buyer. And that's how a novation is structured. So you should never get, as the original buyer, the replacement buyer's EMD should never be paid to you. Now you can structure it so that if the whole deal falls apart, the seller gets the replacement buyer's EMD and then you get the return of your original EMD. If that makes sense.
Mm-hmm.
One thing is, they use the term like ABBC, right? The BC novation. So it seems they're pretty familiar with double closings, I would assume, since they're using that language for double
Right.
escrow, double closes.
Right.
So I know in that world, at least out here, a lot of the parties, they don't like to disclose, right? They like to keep the A seller completely separate from the C buyer. But in a novation, you have to put the two together, right? And so it's a different approach altogether.
Well, and that terminology is wrong because it's not A to B, B to C. It's A to B and then A to C.
Correct.
It doesn't flow through B. It goes A to B, A to C. That's a novation.
And A is tied up with both B and C, and B requires the
Correct.
payment of a cancellation fee to drop their competing contract. But of course, they
Correct.
know this, they contemplate that that'll be the design to start with.
Right. Correct. Yeah. So it's not A to B, B to C, because B is not part of that second contract. So yeah, the terminology there, in my view, on the question was not 100% accurate.
Got it.
Probably comes from how they learned about novations, and hence why a lot of my paperwork on the East Coast doesn't quite accord with what y'all deal with out there.
Yeah, probably. Yeah.
Yeah, Sean, I think it's worth explaining. We've talked about this in episodes before, specifically relating to innovations. In fact, we did an entire episode about it. But you had mentioned that, this is really, and why you don't see this very much anymore, but this was, the replacement contract was used when you were getting a retail buyer, right? That
Yeah.
wasn't an
Mhm.
investor that was getting conventional lending and needed to see the traditional contract, right? Outside of that, there really wasn't much of a reason for it.
Correct. Yeah. I mean, it's basically a way to create a contractual relationship between the buyer, the replacement buyer, and the seller so that, there's no assignment fees or see, in the residential setting, lenders will not lend on an assigned contract. They want to lend on an original contract between the seller and the replacement buyer. And so, but they will pay like a release fee. That's fine. I mean, it's no different than a release of a deed of trust or release of a mortgage. That's fine. You can have that at closing, a release fee. They just don't want an assigned contract. They want their borrower to be the actual buyer under the contract and not an assignee. And so if you have a consumer who's getting traditional financing, that wants to buy the property, then you have to do a novation if they're going to, close using that method. But if you don't have that, then you might as well just do a novation. It's much cleaner that way. I mean, there's no purpose, not a novation, an assignment. You want to just do an assignment if you don't have to deal with that, because it's much cleaner that way.
One thing I've seen, I've had clients that swear they've never seen it, but and I think I've told you all that for Renaissance as well. Some of the lenders will actually cap your fee, right? Even if you try and double close, because lenders aren't stupid. They read their
Right.
title commitments. They know when the seller is not vested with title. And the next question out of their mouth is explain, right? And sometimes you're required to provide the AB contract as well. And whether it's an assignment or whether it's a double close, that lender in Renaissance Bank out of Alabama will do it. They'll cap your return, right?
Yeah.
We will only allow the difference, between the contracts to be no greater than X percentage, and it can
Yeah.
hurt you.
What I do like, and Jeff Watson talked about this a while back on the collective, and it's how you can do basically wholesaling of short sale transactions, which is, and you could do it in lieu of a novation. And I like this better than a novation, which is you take an option to purchase the property and you secure your interest in the option or the seller's performance under the option by a mortgage or deed of trust against the real estate. And then you have an option buyout fee or a release fee for your mortgage or deed of trust. And then you basically are a secured lender getting paid out of closing on an A to or seller to in buyer transaction. Does that make sense?
Yeah, I mean, I'm not even sure you would have to file the mortgage to pull that off because obviously in the commercial realm, right? Tenants will sometimes, obviously if they're big, they'll negotiate and require that a memorandum of lease is filed of record. And of course, the memorandum will reference any options or rights to buy. So, I mean,
Right.
you could file a memorandum of option and, achieve, I think, a
The same.
similar level of
Yeah.
protection, at least out here in Georgia.
Right. The question is whether or not a lender is going to pay out on a memorandum as opposed to securing it, which you have a right to. I mean, it's a deed of trust or mortgage can be secured not only for monetary purposes, but to secure any party's obligation with respect to real estate. So you have a right to secure it by a mortgage or deed of trust, and in which case then, like you were saying before, Drew, like the lender's going to cap. Well, are they going to cap if you're releasing a mortgage or a deed of trust? At that point, you're almost treated as a secured,
It's a payoff lender. Yeah.
yeah, a secured party or secured lender. And so, in that case, I don't think you have as much concern because a lender's going to view you in that capacity as opposed to if you're releasing a memorandum, they may try to cap you, if that makes sense.
Yeah.
If you're just now joining us, we're talking about creative finance, novations, wholesaling. If you have a question, make sure to post it in the chat. Guys, we have another question relating to novations. Apparently, we've struck a nerve and a chord. So let's, I'll read this and
I told you on the East Coast, it may not be live on the West anymore, but on the East Coast, it's definitely alive and well over here.
Oh, yeah. So I'm a TC, so I'm assuming that means transaction coordinator. Many of my clients doing novations will get a POA over the sale of the property, making it at A to B, B PO of A to C. Then they expand this to say one of our TCs that works in Texas stopped doing the power of attorney over the sale. I don't remember the reason, but it was causing some kind of confusion. I'm not sure what the question is there, but
Well, I think the question is what do we think of using a POA to effectuate a novation? And my preference is not to do that, not to use a POA, because I think that's where much of the liability exposure comes, is getting a POA, entering into a new purchase contract on behalf of the seller, Then what happens at closing if the seller objects or you can't close? Now you have exposure to both the seller and the buyer, and it's a whole mess. My preference and why I said it's so important if you're going to do it to have a good relationship with the seller. My preference is to offer the seller an incentive to do the replacement contract. So, say, hey, look, I'm only going to take 60% or 70% of the spread on the two contracts, and I'll pay for any increased costs. So basically, you're going to walk away with a extra, 2 or 3, 4 grand in your pocket if we do it this way. Or whatever amount that works out to. If we do it this way, you'll walk away with more money, but you have to cooperate. You have to sign the purchase contract, and you have to, sign the closing documents and stuff like that. That's my preference, because that reduces and eliminates a lot of the potential liability. I prefer, frankly, not to do it with the POA. I know investors out there are doing it that way, but my preference is to just do it with the seller signing everything on that replacement transaction.
Interesting. Drew, the last time we talked about this wasn't really a thing out in Georgia. How recent of a trend is this that you're seeing with novations out there?
I have a few right now, right? It went from, people would say, hey, this is a new thing, and they'd ship me their paperwork. And, I'd spoken to you guys about it and, been like, I really don't like the language on this. And again, I told you, I actually called the realtors, right? Or their general counsel for Georgia. And, it was like, look, so long as they're a licensed realtor in the language that we had, who cares? It's commissioned by another name, right? That was kind of the thought behind it. And then when I spoke to you guys, it was like, hey, it's supposed to be tied to a notice of contract or something of record, right? Some real contract that, the investor or the wholesaler actually can or intends to perform on in case they can't find a replacement buyer, right? And I think a lot of our guys, or at least, what you're talking about, is just being pitched, right, through these influencers that, hey, here's a new way to set these deals up. But in reality, an assignment or a typical double close is actually a far easier and preferable way to handle the transaction.
Yeah, that makes sense. Scott, I don't know if I know you're out there. Can you hear us still? All right, I'm not getting anything from Scott. If you're just now joining us, this is the Creative Finance Collective. We're talking about all things creative finance and real estate related. So if you have questions, make sure to post them in the chat. We're here through the rest of the hour until folks stop having questions. And so far, we've had a number of questions about novations, and still happy to take more about novations and assignments. Drew, earlier we were talking, you mentioned you had seen a recent company talking about doing assumptions, or we didn't really go too deep into that, but what were you talking about there?
Yeah, so it's called withrome.com, and I'm sure it has something to do with, all the technical side of it, and they're pulling data from the MLS, I would assume, or the various MLSs, right? The multiple listing services. We'll call it MMLS. And they figure out when a seller has an assumable loan, right? VA, FHA, or USDA, and they put it on this website, right? And it looks like they're trying to, because this is not very common. People don't generally assume assumable loans, right? Because most people aren't even aware that it exists, and
Right.
even the process to do one. So they're just kind of aggregating it. And from what I read earlier in a news article, is it looks like they're trying to control the transaction from end to end. So they have realtors they work with on the listing side, right? They have realtors they work with on the buying side, and they have title companies and attorneys they work with to try and make sure that it's a smooth process, because obviously the spread between the old rates and the current rates is pretty severe.
Mm-hmm. Mm-hmm.
I like it. I mean, I think that's huge. And so what they're doing is it's not subject to, it's straight up assumption, right?
Right.
Correct. Yeah. So somehow they're using their technical wizardry to identify homes that have these type of assumable loans. And I guess they're reaching out to the listing agents or the sellers and say, hey, you should, let us get involved with you. We might be able to, help you find a buyer quicker. Because obviously it's
Right.
easier to, it's more attractive to take over on their website to take over a 2% rate than a 7.5% rate.
Do they allow the user to search to see whether their loan's assumable? I mean, how does
That's a great question. Obviously it's all marketing fluff, but they're like, find 5 times more buyer, include your low rate mortgage in your home sale. And so, yeah, sellers can reach out to them as well. But obviously we know it's a very specific class of loans that are in fact assumable. So not
Right.
everyone is going to qualify.
And these are, so this isn't subject to, this is assumption type arrangements.
Pure straight assumption.
And and honestly, if I were a consumer looking to do a subject to for a personal residence, I would be looking at assumptions all day long. I'm not sure I would, me personally, maybe, but like if I were a consumer not knowing, the ins and outs or whatever, I'd probably want to do the assumption as opposed to a subject to, just because, the last thing I would want to do is have to deal with a due on sale clause being called or something like that.
Realistically, though, what does that bucket of people that would really be in play for an assumption look like? I mean, what are we really talking about?
A lot more people than who would qualify for the existing loans because the interest rate is like less than half. And so people who couldn't qualify, people who couldn't qualify for the property at 8% might be able to qualify for that same property at 3.5%.
Yeah. I guess I'm
the
asking,
underwriting will be based upon.
yeah, I guess I'm asking what kind of loans would realistically,
FHA and VA.
yeah, that's what I'm thinking.
But I'm seeing a lot more FHA these days than I used to, like significantly.
As in originated FHA or as in
Yes.
assumption originated?
No,
FHA?
as in originated FHAs. I don't generate. So a thing that's happening here, and it doesn't sound like it's there, is our investors, and obviously the hedge funds have dried up, right? And even there's not investors. So a lot of our guys, they're going straight from, these original sellers directly dispoing to like retail buyers. So now I got to deal with bad titles on the front end. I got to deal with realtors and like conventional lenders on the back
Right.
end, right? So these files are getting a bit rough at my price points.
I'd jump out the window.
Yeah.
Yeah, I've got one. Y'all appreciate this. An email that came in on Friday, and I was asking my middleman. I said, "How are you going to solve this?" And it's been in the family for a while. I've got 11 out sales, and so of course his title, we're like, I need a survey. I have no idea what the boundaries of the leftover, are until the survey is performed. And of course the seller's like, "You said this is going to be easy." Blah 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 blah. And it's like, I don't have a legal description. I can't, my underwriters will not insure 11 less than accepts. Right. I did a survey.
Right. Scott, but between the time we were going back and forth and you were coming in and out, we were talking about novations, and Drew was explaining he's seen them in recent frequency and out in Georgia. And I know there was a time, at least in Arizona, where there seemed to be a popularity in the idea. And I don't know if that's just because investors thought they had found this new cool thing that had a cool name to it. So we're going to try that. But have you been seeing any rise in novations in any sort of frequency in Texas?
I've actually seen a little bit of a decline that I haven't seen a lot of them come through lately. I saw a whole bunch at one time when, as you said, it seems to have been the cool thing to have done along the way.
Mm-hmm.
But, I don't know what all you guys got a chance to talk about because I was pretty much on dead air the whole time, it seemed like. But nobody wants to talk to me about doing novations because They just want to throw money at sellers and throw money out the window without thinking through a deal and what can really happen. They think it's just an easy, quick way of making a quick buck, contracting to buy the property. And these guys want to spend $15,000, $20,000, $30,000 bringing the seller's loan current, then getting in, doing repairs to the property, doing this, doing that, as opposed to what you guys were probably talking about being a traditional novation type agreement where you simply go to contract and more or less sell it to a back-end buyer.
Right.
Where I guess what you're doing is you're circumventing the realtor involved in a lot of cases in those scenarios. But we saw a lot of deals. This has probably been a couple, 3, 4, 5, 6 months ago now, where these guys were throwing money at the seller up front to reinstate their loans, getting in, doing renovations to a property they don't own, and things of this nature along the way. And, I know of at least 2 of the parties who lost their shirts because the sellers went dark, sold the house to somebody else, and walked away. Then they'd call me up and going, "Hey guys, what can I do?" And it was like, good luck filing a lawsuit because that seller's gone. He ain't got no money and you just lost 30 grand. And I just find that seem to be so problematic out there, but it seems to have cooled off and I don't know why.
Well, I think, Sean suggested earlier, and I know here, and we've talked about this in a good bit of detail in the past, but where we've used the novations is to fill in when you've got a conventional buyer whose conventional lender needs to see a purchase contract or doesn't like the idea of an assignment, so you're replacing a contract to help with that. I just think, Sean, I think you might have suggested that I don't think there's a lot of conventional buyers because how expensive lending is right now. So, I think that's just a hard transaction to have happen at this point. So it's interesting to me that it's kind of picked up in some significant way or in some way at all east. And I wonder if these trends just move west to east and then fizzle out. And Drew's just holding the bag right now.
He might be.
That's what I was trying to figure out. Your influencers, migrate their little seminars, right, from west to east, and so they're just finishing up rounds over here, maybe. I mean, I see it on TV or YouTube, right? We never watch TV, but on YouTube, the ads are like, "Come learn how to make money in real estate." I looked at my wife and was like, "I had to go to that just to just to see. Hey, how easy is it? Yeah, tell me how much money I can make."
I want to see you go to that and raise your hand and ask all these appropriate questions that should be asked that the audience doesn't know to ask.
Right.
Because they're all there to get rich quick, as we know, and find that easy buck to be made. But, guys, just as you talk about novations, and we've tried a few of them ourselves in our offices before. And in all honesty, none of them have ever worked. Where we will go in and talk with the seller, and it's not just a contract resale, because these properties typically, the reason the seller needs help is the house needs help. And they don't have the money or the expertise to put into it in order to sell the property into a retail scenario. And so, of course, we try to go in and do some type of a corporate entity, transfer the property into this corporate entity that both the buyer and seller own, and then navigate the processes through simple corporate minutes and an agreement between the parties. Who's going to make the mortgage payment every month if there's an existing mortgage? Are we going to put a second lien on the property to the LLC for the renovation cost to protect the parties? Who's going to pay the interest on that? Who makes the decisions on the repairs? Who supervises the contractors? Who makes all of the decisions that have to be made along the way? Who selects the sale mechanism, be it a realtor or some third-party entity that you can go through that is just a flat fee type listing agreement? How do you reduce the monthly, the asking price, and over what time? Get all these things put together in some format up front, navigate and sell it in that format so that You're able to sell the property, maximize the dollars, help the seller make more money, and you make money along the way, but still protect everybody in the middle. But I just find that in the investor world, none of them want to do that. They don't want to pay for it. They don't want to think about it. They just rather throw money at it and go, well, we think it's going to work out great. That'll never cease to amaze me, what people do. Hell, I'll tell you this one just for a minute, guys. I just foreclosed on a property where we offered the seller yesterday $30,000 to execute a deed in lieu and walk away. They turned it down.
Just
I
let it
foreclosed
go.
today. They got zero. And you're going, what the hey? Anyway, I think it's just people. It'll never change out there in our marketplace. But I do want to go to those seminars that you go to.
I haven't been, but I just saw on YouTube. I mean, and you know what? I may actually still be able to because he's hitting like a different city. It looks like he's moving from North Atlanta to like South Atlanta, like every weekend. He's like, this weekend we're in like, Alpharetta, and then they'll be in Dunwoody, and then he'll be in like Midtown, and then like he clearly is just hitting, little spots along the way through the city. In fact, I should look that up and see about going to one.
I love telling the story. I know I probably told it on before a while back, where same scenario you have where you're listening to Fox News and it's like, come on out and learn snap flip. And you hear that and you go, what? Snap flip. It's a whole new way to, make money. And it was these two guys from A&E, and they spent a bundle of money, advertising on Fox News channels, I guess, to do this. And we're kind of looking at each other going, what the world is he talking about? So like you, it's like, hey, let's just go out and see how easy this is, And we get there. So what was, this is a trivia question. What is a snap flip?
I've never even heard of it.
And this is complicated, guys. It's real. And I know for three lawyers, it's even more complicated. It's a wholesale deal, nothing more.
A snap flip. Okay.
With another name attached to it, right? Anyway, it's all about salesmanship and marketing.
Interesting. Snap flip. So snap flip is just a wholesale.
Yeah, that's all it was. But it sounded really cool, though.
So
just like novations and things like that, they're out there. It sounds really cool. And
yeah. If you're just now joining us, this is the Creative Finance Collective. We'll be here for about another 7 to 10 minutes, taking any questions that you all have. Sean and I just had a show. We were talking with a couple agents and investors today about market trends going into 2024. But it made me think of two things that I thought were interesting. We talked about one of them in during the show, which is a recent statistic that has shown that new home prices year to year from the end of last year to the end of this year have dropped by almost 18%, while resale homes have actually risen over the course of the year. And a lot of that has to do with cost of lending and interest rates and all those kind of things. Resale homes have not decreased in price, but new homes have, because these builders have to sell them. But I thought what was also interesting, Scott, your hero over there at the Federal Reserve, had announced that let's see what the quote was here. The Fed plans on, quote, keeping a policy restrictive until they're convinced inflation is heading back to 2%. Of course, he made those comments in suggesting to folks that who were pricing in not just a pause, but a reversal in interest rate hikes going into 2024. And the Federal Reserve's been pretty consistent so far in what they've been saying. Of course, they could change course, but right now they're saying that they're keeping a pretty restrictive policy going forward. I think what that probably means for creative finance is, investors' interest in it isn't going to change, I don't think, in the immediate future. I think 2024 probably is still going to be dealing with, expensive lending potentially, and the attractiveness of being able to um, either assume, like we were talking about with Drew earlier, assume folks' loans or buy them subject to. But I don't think that industry is necessarily going away, and we're gonna get really cheap interest rates and everything's gonna come back. But I don't know, that'll be interesting to see how that plays out. We're gonna be here for just a few more minutes, so if you're watching, you have a question, make sure to post it, and we'll be happy to address it. Scott, can you still hear us?
I can't, but working on
Oh, okay.
Oh,
No
okay.
worries.
which is a pain in
No
the
worries.
butt. I apologize, guys.
It's all right.
I'll tell you one thing I've learned through some of my larger developer clients is how they're funding the lower interest rates, right? So, if you go buy from, let's say, DR Horne or Pulte or one of the main buyers, right? They're advertising these rates. Now, of course, they're always some form of an arm, right? They have teaser rates at 4.5%, 5%. But the way that they structure those are really interesting. Obviously, as publicly traded companies, they're able to borrow for far less than your typical builders, right? So that's the only reason why the big players can do it, is they have special credit lines set up at lower rates. But not only that, but they're cannibalizing their interest rate to an extent in order to fund the initial sale on their builder side, right? Because when you borrow from them, it's not you're borrowing from a normal lender, you're borrowing from a wholly owned subsidiary, right? So in order for them to pull off a 4.5% rate, locked for 5 years or whatever it is, 3 or 5 years, they're having to cannibalize the interest that they would have earned if they were making, a loan at, say, 8% or 7.5 or whatever it is. So they're intentionally hurting their lending arms financials in order to prop up the builder arms financials. I found it very interesting, the way on the back end that they actually have that thing structured.
Hmm.
Right. You talk about creative finance, sometimes some of the most creative stuff you see is on the commercial side, right? Because they've got the big dollars and the big money to try and figure out, and every dime counts when you've got billions or trillions of dimes.
Yeah, for sure. Yeah, they have more freedom to get exotic in the commercial space, which kinda makes it, interesting. Well, hey, guys, I don't wanna keep you. We haven't had any more questions. It's been a good discussion, a lot on novations, but I appreciate y'all taking the time. Let's do it again, and, you guys enjoy your week.
All right. Thank you.
All right,
Thanks,
sounds
everyone.
great.
All right.
Thank you so
Talk
much.
to you later.
Bye.
Bye, everyone.